Welcome to the Understanding Local and Federal Cannabis Laws course, part of our Cannabis Regulations and Compliance module in the Basics category, presented by the Hemp Temps University. In this lesson, we'll explore the complex landscape of cannabis laws at both the local and federal levels, providing essential insights for navigating legal requirements and ensuring compliance in the cannabis industry. Understanding local and federal cannabis laws is crucial for cannabis businesses and individuals involved in cultivation, processing, distribution, and retailing. Let's discuss key aspects of local and federal cannabis laws. 1. Federal cannabis laws. Cannabis remains classified as a Schedule I controlled substance under the Federal Controlled Substances Act, CSA, with no recognized medical use and a high potential for abuse. Federal law prohibits the cultivation, possession, distribution, and use of cannabis for any purpose, regardless of state laws legalizing medical or recreational cannabis. The federal government has historically enforced cannabis prohibition through law enforcement agencies such as the Drug Enforcement Administration, DEA, targeting illicit cannabis operations and interstate traffic. The Biden administration is poised to make a historic shift in the classification of marijuana under federal law. According to recent reports, the Justice Department is planning to reschedule marijuana from its current Schedule I classification. The DEA is expected to recommend that marijuana be rescheduled to Schedule III, which would place it in the same category as anabolic steroids and certain prescription painkillers. This move would acknowledge the potential medical benefits of marijuana and allow for further research into its therapeutic uses. The potential impact of this alteration on existing cannabis regulations, managed at the state level, remains uncertain. Nonetheless, there's optimism that it could pave the way for nationwide distribution and shipping, transcending states where marijuana is strictly prohibited due to adherence to federal prohibition by state lawmakers. 2. State cannabis laws. In recent years, many states have enacted medical cannabis programs, recreational cannabis legalization, or both, allowing for regulated cultivation, distribution, and consumption of cannabis within state borders, such as Colorado, California, and New Mexico. State cannabis laws vary widely in terms of legalization status, regulatory framework, licensing requirements, taxation, and enforcement policies, reflecting diverse political, social, and economic considerations. States with legal cannabis programs establish regulatory agencies or commissions to oversee licensing, compliance, testing, and enforcement activities, ensuring adherence to state laws and regulations such as the MED, Marijuana Enforcement Division, in Colorado, or the OMMA, Oklahoma Medical Marijuana Authority, in Oklahoma. 3. Local cannabis regulations. Local governments, including cities, counties, and municipalities, may enact their own cannabis ordinances, zoning regulations, and land use policies to regulate cannabis businesses within their jurisdiction. Local cannabis regulations may include restrictions on cultivation sites, processing facilities, retail dispensaries, and consumption lounges, as well as buffer zones, licensing fees, and operational requirements. Cannabis businesses must comply with both state and local regulations, obtaining necessary permits, licenses, and approvals from local authorities in addition to state regulatory agencies. 4. Compliance and enforcement. Compliance with local and federal cannabis laws is essential for cannabis businesses to operate legally, avoid penalties, and maintain public trust and legitimacy. Many states require background checks, fingerprints, and/or state-issued licenses to work in the industry per their state. Cannabis businesses must establish robust compliance programs, internal controls, and standard operating procedures, SOPs, to ensure adherence to regulatory requirements and best practices. Regulatory agencies and law enforcement authorities may conduct inspections, audits, and investigations to verify compliance with cannabis laws, addressing violations through warnings, fines, license suspension, or revocation. 5. Legislative and regulatory developments. The legal landscape of cannabis is dynamic and subject to ongoing changes, with new laws, regulations, and policies emerging at the federal, state, and local levels. Cannabis businesses and stakeholders should stay informed about legislative and regulatory developments, engaging in advocacy efforts, industry associations, and compliance training to shape policy outcomes and stay ahead of regulatory changes. In conclusion, understanding local and federal cannabis laws is essential for compliance and success in the cannabis industry. By staying informed about regulatory requirements, maintaining robust compliance programs, and actively engaging with regulatory authorities, cannabis businesses can navigate legal challenges, mitigate risks, and contribute to a responsible and sustainable cannabis market. Thank you for joining us in this lesson on understanding local and federal cannabis laws, part of our Cannabis Regulations and Compliance module in the Basics category, presented by the Hemp Temps University. We encourage you to continue your journey into the realm of cannabis regulations and compliance by moving on to the next lesson.